Marco, how are you?
I'm good. How are you, Maya?
I'm fine, thank you. It's very nice to see you. You're a wicked ally, and you were a guest on this show, and it's a recurrent guest. So it's always nice to have you again and back to the series. How have you been?
I've been good. I've been, starting off 2025 on a couple positive notes with some interesting cases. So I'm happy that 2024 is behind us. It was a long and very busy year. And I know that a lot of what we're going to be discussing today involves practicing in Superior Court. And last year, a big bulk of my time was spent in Superior Court. Doing back to back a lot of Superior Court trials. I did five jury trials in a row, and some peppered in some provincial court things in between. But overall, it was an eye opener in terms of the impact of practicing in Superior Court on practicing law and changes and adjustments that I had to make in my practice to accommodate that sort of schedule and reflecting on that it's not something that I think I would recommend or do again. So I try to make adjustments to avoid getting caught up in such a schedule like I was caught up in last year.
Okay, so this is exactly then what we're going to be talking about, and it is how to manage a practice when you have cases in superior court, when you're either on your own or in a small firm environment, which is your case. I mean, you do have a firm, but it's a relatively small firm, and having cases in superior court is a completely different dynamic than in the Ontario Court of Justice. And so you, as you mentioned, you've been doing a lot of superior court work last year. So tell us, Marco, I mean, what were some of the challenges that you faced? Was it just time issues, or is it, I mean, the law is the same, so it can't be that it's in terms of the law, it's different, but uh, uh, time is probably different. The Jordan ceilings are different, but what else is there?
Well, well, starting off, like, I think even just when I reflected on the whole year, how did I find myself in a circumstance where I did five back-to-back Superior Court trials. And the reason why that happened was the pressure that I think defense counsel specifically are facing in terms of scheduling our trials, particularly scheduling Superior Court trials, because this is all still kind of a backlog from COVID and trials that didn't get scheduled sooner. So all of these arrests occurred, let's say, between 2021 and 2022, so the tail end of the pandemic. And here we are in 2024, and they're all kind of getting to trial, some with mostly with 11B waivers, et cetera. But because otherwise they wouldn't have got there sooner, and the schedule just became, really jammed packed. And so looking ahead to that, and when I was still in 2023, I made some decisions. Like, for instance, I hired an associate, which I never hired before, because I figured, I'm going to need an associate to assist with the rest of my practice because I'm going to be jammed up in court that much. So then that was one decision that I had to make, which a lot of people are not in a position to necessarily do that. Just be like, oh, I'm just going to hire somebody to help me. So that was one thing that I did to help offset. But then there's other stuff that you don't really factor in is like, for instance, I did 3.5 weeks in Ottawa. So I'm from Toronto and I'm doing an out of town trial. The impact that that has on, on your home life and things, because just because you're doing a trial, the rest of your life doesn't just stop, right? And the thing is, with Superior Court trials, as opposed to like the provincial court, Superior Court trials, they carve out a period of time for you, often in a lot of jurisdictions, and they expect you to get it done in that time, whether it's judge alone or jury. If it's a jury trial, then getting it done is really important. If it's a judge alone trial, there's still a lot of pressure to get it done in that period of time. I feel like in the provincial court, there's a lot more, because of stacking and trial stacking and pushing things over. You might get a couple of days of evidence in, then it goes over a couple
Yeah.
months, you find another date, etc. And trials kind of get continuations along the way. But in the Superior Court, hey, we've given you this time. We're going to devote our attention to this matter. So you have to get it done. And what that means is for that period of time, whether it's a 2 week trial or a 2 month trial, you're in that one case. But the rest of your practice doesn't stop. People get arrested, bails come up, other clients
Oh,
need
bails
attention.
always come up when you're busy in a trial, right? Like I
Right,
find it's
exactly.
always.
Exactly. And then there's arrest. Then you get crown attorney sending you messages. Oh, you never got back to me. Can we schedule? So next thing you know, you're doing a JPT at 8:30.
Mhm.
You're
Or during
stuck
your
late
lunch break.
during your lunch breaks. You're doing this. I remember specifically when I was in Ottawa, like I would have to go and squeeze in JPTs on lunch every day, and so you have to shift gears from your trial and all that's happening there and switch into another case, do a JPT, and then switch back. And it's fine if it happens once in a while, but when you're in a lot of these cases, one after the next, it becomes very difficult to manage the rest of your practice. And then, often, you know, things might come up, both like on your practice. You might have somebody get sick at work and they need a day off or 2 days off or whatever. Then you have to juggle that around. And clients are calling or something. It's never that something is just perfectly smooth. So having a good support staff to handle all of the backlash while you're busy in court is important. And I not everybody has that opportunity or that benefit. Like I spend my commutes from court to home on the phone with each one of my staff as much as I can to find out what's going on and if there are any fires that need putting out. So, you're spending all day in court, you're wound up, you're rushing to get home. And because, I have young children, etc. So, after work until bedtime is really like a busy time in my house. So I have a small window from when I leave court till I pick up my kids that I can talk to my staff. And if there's any fires that need to be put out, they got to be put out in that window. Then you rush home, you do what you have to do for your family, and then at night you have to kind of like, go back to preparing for tomorrow.
So,
And
but then,
yeah,
we keep hearing about this work-life balance concept that they keep talking about all the time, but it just feels almost impossible, right? Because on the other hand, when you also get suggestions for dates in court, they always want the defense to be available. There's always this undertone of, well, why aren't you available? Like, what else do you have to do? And then we have this whole thing of work-life balance. So it's just becoming more and more challenging, and especially when you take on superior court cases.
exactly. And I think back to this article written by Justice Strathy just before he retired as the Chief Justice, and it was about this idea that like lawyers are gladiators. I think was the term gladiator or warrior. I don't recall, but basically this whole idea that we are always expected to be ready for battle and go into battle and etc. And you read that article and it basically says like we have to focus on our own mental health. We have to focus on our own ability to cope. And this idea that we pride ourselves on being able to handle the pressure and grind ourselves into the ground. And that's not just the defense, that's the crowns as well. And the scary part is, and people ask me, well, do you think that that's going to ever change? I don't. I think that in a large measure, the reason why it doesn't change is because judges also have that same attitude, right? Judges have the attitude of like if they take on work, they work like especially in the Superior Court, they work long hours. They'll send you a draft jury charge on a Monday morning that they've spent all weekend working on, or that sort of stuff. So if they're saying to themselves as the boss, and if you look at a court case or a trial as like the judge is the boss of the trial, if the boss is working on weekends to do their part to make this trial complete, they have the same expectations as you. And so if the judge imposes those expectations on you, you're going to say to the judge, "Oh, Your Honor, I was too tired yesterday to do this, so I can't do X or I can't do Y." It's not. We don't have that. We're not going to behave that way because it's like it's not part of the litigator's culture to say something like that. We don't feel comfortable saying something like that. And as much as Justice Drafty was trying to say it's time to change, that culture, it starts from the top. And frankly, I don't see that the judiciary is, taking a step back and saying, well, we're not going to work this hard, so we're going to slow the pace down. Because they're getting pressure. Trials have to be finished. The deadline is this. We can't afford 11Bs and so on and so on. So they feel their pressures. They download their pressure on counsel. Crown counsel, they have their own pressures, whatever they are, and they download it. And it all kind of comes to a grind into these trials. And we're supposed to live with it and cope with it. So it does become difficult. And I resolved this year that I'm never going to do another year like I did last year, um, because it was just too much. It just became it was too much by the end of the year. Just I never thought, and I've had busy years before, but by the end of the year, I started to really appreciate or understand that idea of burnout.
Hmm.
Um, which it's not just because of work, but then, come home, family responsibilities. This, like, everybody's got their own personal circumstances, kids, aging parents, bills to pay, whatever it could be, illnesses in your home, whatever it is. You also have that when you come home. So it's not just, oh, we're lawyers, so that's our number one and only thing in our lives. So it all kind of comes together. And when you're doing a Superior Court trial and you're expected to be at work at a particular pace, I think a good piece of advice, to which I've always done, but I'm doing it more now, is if the trial's 3 weeks long, I block off a week before and I block off a week after. The week after is probably more important than the week before, because the week after, if anything spills in, you don't want to get caught doing the German applications and so on. So you book a week after. You over budget your time. Now people are going to say, yeah, but by doing that, you're losing, like, you're giving up valuable time. But if you don't do that, when you're in a trial coordinator's office, especially on the smaller matters, oh, Mr. Sciarra, your murder trial is scheduled to finish on this day. Your next trial finishes 2 weeks, starts 2 weeks later. Can we do this trial in the 2 week interval period? It's only a 2 day domestic or a 1 day impaired. Or so now I'm shoehorning provincial court stuff between major. Those clients deserve a certain amount of attention.
Yeah.
And it's those little things that start to contribute that I think as counsel we forget. Like, just because there's gaps in our schedule doesn't mean that we should be filling those gaps with. Sometimes it's better to just leave them open, because you have that 2 week. You don't know what's going to happen in that 2 week period. Somebody gets arrested. You might have a special bail. You might have something to do, or just sit down and prepare. That's also a thing you're allowed to do, right?
But one of the problems that we're seeing, especially at the OCJ level, is this stacking that we
Correct.
have on the same day and in the same courtroom. You have multiple trials that are scheduled, and you don't know if your matter is going to proceed or not, or if it has priority or not. You'll just find out on the day of. And that has been a challenge. But I mean, how much of this is also an issue of not properly screening the cases that really should be going to trial? I find like this is really the biggest frustration I find right now. There are so many trials and so many trials on really stupid cases that shouldn't be taking trial time. But how do we change that? It's
So that's a good question. I know that Adam Bonney, who's been a guest on this show, is a
yes,
big advocate of this on LinkedIn. He's always advocating about that, and I think what we're in Ontario, what we're in denial of, is the fact that in British Columbia, and my colleagues who practice out there tell me that this pre-charge screening process has been really helpful in getting rid of matters that should never be
yeah.
charged. And that would probably be a good step to take in Ontario. And one can only, I know what you're saying. Like, a lot of times we set down minor things, and then they get pulled on the day of and stacking, whatever. But you can even see it on, like, I would imagine that it could also be helpful on a larger scale. For instance, you know, in large prosecutions, a lot of these project cases, a lot of time charges end up being, laid on people who are not, they ultimately get withdrawn or and so on. Like
Yeah.
having a Crown input on whether people, you can arrest people and not charge them. Like you don't
Yeah.
have to charge everybody you arrest. Um, like for instance, when they do a search warrant, they know who their target is. There's no reason that necessarily they have to charge the grandmother, the mother, this, and all these other people because they were all there, and then ultimately it gets sorted out in court. Like Toronto, Ontario has that approach that it'll all get sorted out in court, but you know resources that are eaten up by having a multiple accused trial versus sorting it out. Like on this recent case, this drug case they did, the original arrest was 8 people, several JPTs, pre-trials, etc. 5 people were ultimately cut. Some people were given stat decks, but scheduling pre-trial, scheduling things, 8 lawyers, resources to each of those lawyers, crown attorney has to sort everything out. Like all of this is judicial resources. The judge has to say, can't you cut this person? Can't this person get a stat deck? Can't
Yeah.
this, can't that? Right. And then 3 people go to trial on the pre-trial motions. Midway through the pre-trial motions, it's down to one person. The Crown decides to stay the other 2. So like out of 8, you're proceeding on 1, 7 people, that might have been something that could have been sorted out even before you made the charges. You might have said, okay, just charge 3, get rid of those 5. And then the process would have been it would have moved a lot more quickly. And in that specific case, because of the original charge, the Crown got into 11B concerns early, so they preferred an indictment. So the matter then went straight to Superior Court because then they had to make this decision. Well, are we ever going to get this trial under, in provincial court? Are we ever going to get it done? No. So maybe we'll have to prefer an indictment. So now you're eating up judicial resources at the Superior Court level, and you preferred the indictment. Then you withdrew against 5. But scheduling, it just becomes a disaster. So yeah, a lot of work has to be done up front to sort that out, and it impacts on how both the provincial court and the Superior Court
Yeah.
will proceed.
Well, because
It's all interrelated.
and
Sorry, go ahead.
here's the issue. So, I mean, um, I think in Toronto, it's the same phenomenon that we're observing in Ottawa. We have more and more new crowns who are given cases. They're team leads. They're assigned these cases, and they're the ones who screen them. And they don't have a lot of experience. And some of them, because they don't have experience, they take unreasonable positions, and they're stuck and stubborn on these positions. And from a client perspective, it's like, no, obviously this is unreasonable. So you end up going to trial for that. What I do from a defense perspective is that when I see right away, because sometimes some cases, just from reading the facts and the disclosure, right away you can tell that this doesn't deserve to go to trial and it can be resolved. So I always, for these types of cases, I will prepare a pretty thorough CPT memo that I call and I send it to the Crown. And sometimes some Crowns, when they read it, they're like, okay, I've reviewed your memo and I reassess the case and I agree with you. Okay, let's resolve it this way. It helps. But again, it's defense doing the work for the Crown when it should be the Crown's. I mean, why don't they have someone who's senior, whose job is to properly screen these cases and make sure that only the right ones go to trial? Like, isn't it something that the Crowns can do you think, Marco?
Well, when I first started practicing, that's how it was. So when I first started practicing, it was there was Crown attorneys that were assigned to the case management, what they called case management, and they would review all the files.
Mhm.
And then if it was a matter that couldn't be resolved that went to trial, then it would be assigned to a trial Crown. And then that Crown would get the files, show up to court. They would come to court in the morning. That have 6 trials scheduled in one court, but they'd show up in that morning and say, "Okay, Marco, you're on this one. Okay, would your guy take a peace bond here? The witnesses didn't show up. Whatever. Done. The next person. Okay, we're gonna hold this one's important. We're gonna hold this. This is on. It's second in priority. This one can we resolve now? So like that trial Crown who would get the files maybe a few days before would have to like call the cops, find out who's coming, where the witnesses are, have they been subpoenaed, etc. And then they can make their final. So there was this philosophy from the defense bar when I first started that, never plead anybody out, always set trial dates because you never know what's going to happen at the day of trial. That may or may not still be true in this system. But what was happening back then was that, in various courthouses, like I remember in Scarborough, they called it the cave, or, and like you would go in any day of the week, you sit there and you say to the crown attorney who's in court or in the cave, hey, yeah, I have a matter, John Smith. They would go into their crown's office, they'd go into their filing cabinet, they'd come out with the brief. It didn't have to be a Tuesday matter, it didn't have to be whatever. It was just pick up the brief, they would read it, they would say, okay, what's going on? Then you would say, look, I think this, here's what I have this letter, I have this, can we resolve it? And then that crown attorney, their whole job was, can we resolve it?
Hmm.
And so they're not looking at it for this is going to trial. They're looking at it, how can we resolve this? And what are you showing it? So going in that you're there with a view towards maybe getting to a resolution. Otherwise, you don't need to do that to set trial dates. You just, fill out the form, check
Yeah.
off the what you need done, and it's done. So I like that approach when it was happening because it made it a lot more cost efficient for us as counsel too and our clients because, you know, your client didn't have to, now you have to take it through every step of the process because and put yourself in the position of the crown attorneys. They get handled, let's say they get 100 files. I think they say they get about upwards of 200 files. If you got to manage a file from beginning to end, everybody knows that at the beginning of the case, the file looks great. And at the end of the case, it looks significantly different.
Yeah.
But if they have 200 of those, how can they really like focus that attention on each and every one of them? Some are more serious than others. And they're not just, they're busy and they're swamped and probably burning out too. And are just saying, well, whatever I can put on the back burner, I will. If a defense lawyer now shows up and persuades me to withdraw something or persuades me to resolve something, then I'll look at it because, yeah, we've done the work for them. So that's kind of how it's become now since they've switched to vertical case management. But if they really want to clear some backlog, I think in court, reverting back to that would be the better way because the crown attorneys who were often the ones in those positions were often the crown attorneys who could see what was a good case and what was bad, could see a case that was probably not as strong as they thought. Sometimes they might say, look, I can't give you an offer right now. Let me talk to the OIC. Let me see what these witnesses are all about. For instance, if it's like, drug addicts or people who just maybe transient or whatever, like they're not going to, a lot of them could see right through it and say, yeah, it doesn't look like these people. I'll be surprised if they could even find these people. Let's do it now, as opposed to wait till the day of trial. Okay, witnesses didn't show up. Because that was a more efficient way of doing it, I thought. And like every courthouse had their little quirks. Like some of them, on Wednesday, like I remember at 1,000 Finch, there would be 2 or 3 crowns that you would have to go if your guy was on the docket in Sete Court, you could sign them up for a pretrial. They would get the brief. You go out into the hallway, sit in the private corner of the hallway, and just chit chat about the case, right? And it was
Yeah.
like there would be 3 or 4 crowns in court. They would take the brief. You would sit there and go, I hope it's this crown that gets my brief. I hope it's that one.
Yeah.
Or
Yeah.
sometimes you would whisper to a crown, hey, I'll wait for you. I'm here. I got time.
Yeah.
And like, because you have a good relationship. The other thing,
And
Maya, is that,
the ones who are reasonable.
right. But the other thing is, even who we think are unreasonable, they might be unreasonable in our opinion of them unreasonable. But if you build a relationship with somebody because you speak to them face to face, you're sitting there, you're
Yeah.
presenting things, you're not just somebody behind them and just reading an email. Because I don't understand. I would get anxiety when I write an email to the crowd. I always think to myself, if I was on the other side of of this computer, how many of these emails do these crowns get a day? Like
Yeah.
I
Yeah.
can't see more than 10 emails in my inbox. I get anxiety.
Yeah.
So if I'm a crown and I'm getting 200 emails a day, I'm not going to give it any attention because it's just going to be overwhelming.
Yeah.
Right. So it was so much nicer to just be able to like bump into somebody, sit down with them, chit chat with them and say, what do you think? How about this? How about that? They can get a sense of the person that they're dealing with because we're forgetting that this is a very personal business. This is a human business, and sending emails and versus talking to somebody and looking at them and saying, "Come on, like, can we work this out? I really don't want Sometimes, crowns can understand the frustration in your voice if you have a difficult client. You're not going to say, oh, my client's unreasonable, my client's difficult, but you say, look, I don't, this client, I don't really think he's going to accept that offer. But I think if we could come to this position, I think that's something he could, like, they can see that in your, like, that becomes not something that you're typing down in an email. It's something that you just having a conversation about. And the crown then could sit there and think, hey, you know what? Maybe we can get there. But
Right.
we don't do that as much anymore. And so therefore it becomes a lot more complicated in order for us to how do we resolve matters. So things just, you're right, frivolous things just get sent down for trial because there's no talking to anybody. There's no
Well,
actual like dialogue.
but that's also when the judges can't step in, right? Like at a JPT. So if let's say the Crowns are like, no, I don't care, like, well, then take it to trial. But then when we're having a JPT, because if a matter is going to trial, it's most likely going to have a JPT, especially if it's more than a day. But then here's when the judges can intervene and say, well, no, I'm not going to give court time for this crap, like they can do something here and be more firm as opposed to just being like, okay, 3 days or 2 days or a week or of trial. Like judges can also have control here and just limit the types of cases. And I find like this is one thing that is frustrating in the system. Not every case deserves to go to trial or should be going to trial. Like we should let go. Some things are less important. So many of the domestic cases, especially if they're minor, first time, we don't need to have a trial on these cases and they can all be resolved. And sometimes the parties themselves want these matters to be resolved and the charges withdrawn. But we sometimes crowns don't want to listen. They're like, I don't care, like what they say. There's a reasonable prospect of conviction, so we're just going to go, even though both sides don't want to have a trial. So it's just holding
That's
on
a,
too much.
it's a very interesting. This is a very interesting thing, a phenomenon that you're touching on here. The judicial input has suddenly, I feel, become, on the one hand, if judges provide input, crowns are not shy to say, well, no, we don't agree. We're not going to proceed. We're
Mhm.
not going to, if he wants to resolve it, he can't resolve in front of you or whatever. Like that used to be very uncommon. I remember when I was young.
Mhm.
In fact, it was basically almost a guarantee that if the judge, when I remember starting, if a judge would say, look, Mr. Crown, I know you want, 60 days. I'm prepared to give him suspended sentence. You can ask for 60 days. I'm going to give him suspenders for all the reasons set out here. There was a time when a Crown would be like, well, then I'm off the hook.
Yeah.
I can go, I make my pitch for 60 days. Judge does whatever he wants, etc. And now all of a sudden, the crowds are like, well, if that's your position, Your Honor, then we're not going to plead in front of you. And so now judges are starting to become more reluctant, I think,
Yeah.
because to to give their positions in JPTs or to be more firm in JPTs because of that concern. I think maybe I'm not 100% sure, but it's a very peculiar thing because we used to bank, and I don't want to use the word judge shop, but you used to like hope to get like a judge at a JPT that you know would the crowd would listen to and respect, and you could probably persuade and say. So then the judge would say to the crowd, "Look, they have a good point. This witness is this, or we have that, or whatever it is." And persuade the crowd. So then the judge would persuade the crowd to come around your
Yeah.
way. And I feel like a lot of that is kind of fallen. Now it's about checking off the boxes on the JPT form, and judges are more reluctant to impose that opinion. And also, I just feel that more importantly, crowds are more emboldened to say, well, if that's the case, Your Honor, we're not going to do the resolution with you, which from the defense perspective, you never had to say that because you wouldn't have to say, well, I'm not going to plead in front of you. Because as a defense lawyer, your client could plead any day of the week in front of any judge they want.
Mhm.
But it's the crowns who are the ones that are standing up saying, oh, we don't feel that we're going to plead in front of you. And then So what's happening with that whole part of the that step in the process is it's not as effective as it once was. It used to be a very effective step in the process, and now it's just becoming another step where we have to fill out boxes and forms. And I'm not sure why. I'm not sure if there's some sort of lack of respect for the opinion of the pretrial judge. I mean, at the provincial court, I see it more. I think in the superior court, there's pretrial judges, especially on serious cases, their opinions are carry a lot of weight, especially when you're
Yeah.
talking about several weeks of court time. But in the provincial court, it's like, well, no, we're going to have the trial. We're not going to let them resolve in front of you. It's
Yeah.
like,
No, but this is a really important point because I've been noticing the same thing as well. I find for the same case, if I have a JPT, sometimes I'll have it first at OCJ level, and then if I decide, okay, no, I'm going to Superior Court, even the Crown will change a bit their attitude once we're before a Superior Court judge. And I don't know why, honestly, like why something that they were reluctant to think about before when it was at the OCJ. Then when the judge, a Superior Court judge tells them no, like I'm not prepared to waste court time on this. Try to do something or rethink your position. Then they think about it. But what's the difference here? Like they're judges,
yeah,
so
I'm not sure. I mean, I don't know if there's, I don't know. But yes, in in the JPTs in the Superior Court have a completely different tone than JPTs in the provincial court. And in the provincial court, I just feel like, yeah, I'm not 100% sure why the judicial input is not carrying. I feel like it's not carrying as much weight as it used to. Whereas in Superior Court, it carries a lot more weight. And that's troubling because we relied, as defense counsel, oftentimes we relied heavily on our judicial calling, our judicial officers to impose that. And I remember, like specifically, some judges in smaller jurisdictions would say to the Crown, "Look, write it in the brief. Justice so and so says X, Y, and Z. Go talk to Mr. So and so, Miss so and so, the head Crown, and go tell them that Justice so and so said this, and let's put this to bed." And that individual, the impact that that would have on that individual Crown would be, hey, kind of gets them off the hook, being responsible for this potential outcome, right? And so they would go back and come back and be like, okay, I can let you plead in front of Justice so and so, and he can get whatever he wants. It absolves the Crown from any, you know, agreeing to anything. I feel like now everything is it's got to be a joint submission. Like going
yeah.
in open is not even something that people even want to do anymore
It's
because you
becoming
have,
risky. Yeah, no, it is
yeah,
becoming risky,
but
and
why? Is it
I don't
because
know.
we don't know we don't know which judges are going to give what when, and I'm not sure. I'm not sure why this is happening, but yes, it is becoming risky.
Well,
Um,
one on the JPT issue, one main difference between an OCJ and SCJ JPT is that a JPT in the Superior Court is a lot more work because you have this long form that you have to fill out. So you can't just like take any case like that. You really have to think about these issues and make sure that you have, something proper to give to the court. Whereas it's not necessarily the same thing. I personally prepare memos even for OCJ JPTs, and that helps a lot. But still, I mean, I don't know if that's also a factor that for crowns, they know that they can't go with the same attitude and not be as prepared when they're going to an SCJ case as opposed to OCJ. I don't know if that's also another factor that's involved and that has an impact on the crown. But I mean, I feel like there are a lot of problems right now in the crown offices, unfortunately, that are making it more difficult to practice
well,
criminal defense.
I think that in the OCJ, I think that in the SCJ, is what carries the weight is the fact that the trials are so long. And because they are so long, like, are we going to really blow 2 weeks, 3 weeks, 4 weeks without really putting a thought to it? Whereas I think in the OCJ, it's a 1 day trial. Ah, it's a 2 day trial. It's more minor. Oh, it's a 1 day trial. Oh, it's a 2 day trial. And so, yeah, maybe you're right. The thought doesn't go into it, or the consideration of the issues, and the real consideration of the issues is not there. And judges have to fill out this form, so they're just filling out legal issues, legal forms, and that sort of stuff. So this is where the I think the main difference becomes between the two. And I feel like in Superior Court there is more thought put into it, and the discussions are a lot more thorough. Look, in the provincial court, the judges go through a very thorough checklist now as well in terms of legal issues and so on. But a lot of those issues are like the defense have to address. A lot of
Yeah,
those issues are defense questions pointed to the defense, right? Because they're judge alone trials, they're not jury trials. But when you get into a jury trial, then the Crown has to expect is the Crown bringing a motion for other disreputable conduct? Is the Crown bringing a motion to, do this? Is the Crown bringing a motion to do that? And because there's a jury present, all these tend to be more Crown issues. So if you notice in the JPT form in Superior Court, a lot of like a significant portion of it is directed at the Crown and
right.
the Crown evidence versus in provincial court, it's more is the defense bringing a charter application? Is the defense doing this? Is the defense doing that? Is the defense doing this? Right? And obviously it's disclosure complete and so on. Number of witnesses, concessions, the defense made because the judge is on trial, so they're not very concerned about prejudicial evidence getting in because they hope that the judge won't affect them. But the Superior Court is not necessarily like that, and the form is very thorough and it's geared more towards the Crown attorneys. And if you elect judge and jury with the potential for re-election, and then the Crown will identify in that case, well, this is all the prejudicial stuff that we want to put in, other disreputable conduct, etc. And then the judge will say, well, if it goes judge alone, do we have to litigate all these motions, or can we sort certain things out? And it becomes a lot more streamlined. So it starts big from the Crown and then it gets streamlined. Whereas in provincial court, it's not that concern is not really there. And so what ends up happening is in provincial court trials, things go off the rails simply because of some of the things that the Crown decides that as they face the trial, defense wasn't ready for, and then all of a sudden you need more time,
Yeah.
right? It's like, oh well, what about this? Well, that wasn't discussed, and now you want to put it in because now you're starting to see your case a little bit differently. And so then things start getting adjourned and so on. So that becomes a problem. But I agree with you. There's some weird phenomena happening in the provincial court that resolutions um, you know, are not as easy to come by as they used to be in the judicial pretrial process. At least that's in my. I mean, look, there's probably some judges out there who say, "What are you talking about?" In my court, they always, yeah, but maybe because this judge, some judges are considered really up the middle, and everybody's comfortable with them. Like if there's an opinion that a judge is more to the defense, the crowds are saying, "Well, we're not going to plead it for you."
Yeah.
It's like, what do you mean? Judge is judge,
But
you know?
because, I mean, when you have a judge who is firm on not allowing some of these frivolous cases to proceed, they do have an impact. I mean, like when you have a JPT at the OCJ level in front of a really good judge who's really reasonable and has a good sense of common sense, it does help because they will be firmer with the crowns and they will let them know, that this is a case that, well, if you can't make that decision, you can maybe go and check with your office and ask them what they think. So I think the judges do have a role as well to play
Right.
here, especially because right now we have a wave of junior crowns who maybe are afraid or they don't have enough experience, so they don't feel like they can really change their positions too much unless they get feedback from their offices. So that's when the judge, I think, has a crucial role to play in this whole process.
But that then what ends up happening now is, oh yes, let's go back. So then we got to come back for another JPT. Then possibly the Crown needs a little bit more time, maybe another JPT. Got to call another JPT, and all of a sudden you're doing 3, 4, 5 JPTs on a
I
matter
agree.
to get a resolution. Who pays for that?
I
Legal aid.
totally
If it's a
agree.
legal aid client, they're not paying.
I agree, Marco. And I mean, it's funny you're saying this because I had I just had a case. Finally, eventually, the charges were withdrawn. Um, it started in OCJ, but then I decided to go to SCJ, and I've had maybe six JPTs, and it was very obvious from the beginning because I prepared a memo right from the beginning showing all the evidence that I was going to show at trial that really shows that the Crown has a very weak case. The judges were saying this to the Crown. The Crown kept going back and saying, "Well, I have to check with my office. I have to check and I have to do further investigation." We had like maybe six JPTs in total between OCJ and SCJ for them to eventually say, "Okay, we're going to withdraw or stay the charges." So it's, but how much do you think 11B though is a problem in all of that? Like I feel
Well,
11B is the biggest problem we have in our system
it
right now.
maybe it is. I mean, obviously, 11B plays a factor, but in a case like this, where like you're explaining, where you're pushing for a withdrawal, and the Crowns they'll say, well, if my friend's willing to waive 11B, we'll call the police officer and we'll come back for another JPT, and we'll take those steps, or we could set trial. That the moment you set those trial dates, all of these efforts are going to be put
Exactly.
on
Yeah.
the back burner.
Yeah.
So they get you between a rock and a hard place, and all this stuff is not really, that's why the old process of case management, the Crowns that you deal with in the case management would be like, look, give me a call in a couple of weeks. If we can't get anywhere with this, we'll sort it out. And it was always like you're just dealing with these Crowns that are just in the case management. They would do it for 6 months or whatever their term was in that case management side, and then the next team would come in and do that. And nowadays, if you set trial dates, I guess that they get told that this is going to be a trial dates are set. Too bad. Like, I'm not going to look into this any further. And you feel it until like a month before the trial. Hey, what happened? Doesn't your guy, I thought your guy was going to take this deal, but now, we have trial dates set. Like, because it's like they totally forgot that. And then next thing you know, deals get better. And it's a very hard thing to explain to your client
Yeah.
to turn down a deal now, pay me to prepare for your trial, only to get a deal or a better deal closer to the time of
Yeah.
trial. Because the client's now, oh, I'm going to be suspicious of you. Like, why couldn't we do this a year ago? Why
Well,
did I have to
because
pay
it's
you
their
more?
lives, and rightfully so, to be honest, because
Mm-hmm.
their lives are on hold. Many of them can't
Mm-hmm.
work until the case is completely over and they know, are they going to get a conviction at the end of the day or not? So,
Right.
I mean, and the clients, I can understand their frustrations. They're human beings, they have lives, and they're going to be on hold for as long as this case is going on. But I mean, again, I find like it goes back to the crowns. They have the discretion and they just need sometimes some common sense that I find is sometimes lacking these days, unfortunately.
Yeah, I mean, look, that's how it would appear on the surface, but I think if we circle back to really what's happening, I think in our profession, especially on the criminal side of our profession across the board, it's just really more a function of burnout. I really think it's a function of overwhelmed. Look, the reason why there's a lot of young crowns is because there's not a lot of old crowns.
Mhm.
Or simple as that. And what happened to the old crowns? Are they leaving? Are they seconding? Are they retiring? Young crowns are coming in. They're probably overwhelmed. We keep, the term common sense is very vague, but the common sense comes with experience. How do you get that experience? You have to do cases, you have to do trials. How do you do trials? Well, you have to be able to separate the wheat from the chaff. Maybe they're not there yet in terms of making those decisions. Um, and so we get to this point now where everybody just seems overwhelmed from their own perspectives. And, we're at a time in our careers, you and I, where a lot of our defense lawyer colleagues are turning to the Crown's office.
Mhm.
And it's funny because when you talk to them, and if you sit down and talk to them, they will say it's easier for some reasons, but it's also difficult for other reasons. In terms of volume, like, I don't have a large practice, so for me, I think it would be overwhelming to have to all of a sudden handle 200 files. Like,
Yeah.
I've never had that. So I think that would be daunting, having to show up, work 9 to 5 days, and go into bail court or plea court or whatever. I don't know. I don't know what that's like. And I think a lot of our friends who go there, yes, they don't have to worry, for instance, about where their next paycheck's coming from, which is an important thing. Maybe they got some more job security. So that's a relief on that side of it. But the actual work could be overwhelming. And then we're sitting here saying, well, just this is simple, just exercise common sense. And you might be right, but you are one of, let's say, 200 other defense lawyers saying, come on, just exercise common sense. Right.
Well,
And so
that's
they're
an
saying
issue on
everybody's saying the same
Well,
thing.
but that's the issue on the Crown side is they don't have enough time to really look into the case. And this is why maybe it is important to have that old system back that you were talking about, where there's someone who's assigned specifically to take the time to look at these cases properly. Because I'm confident that if someone did really look at the cases properly, they can see just from reading many of these cases that we don't really need to be too stubborn about them. They're not that serious. And some of them, they're also very weak from a Crown perspective. So,
I think that I'm not 100% sure, but in my discussions with some more senior Crown attorneys, I think that that type of change has to start from the very top, like the
yeah,
Attorney General's office. I don't think it's something that is necessary. Like before, it used to be done maybe on a courthouse level, but I think that that philosophy has possibly shifted. I could be wrong. So it would have to be something that starts near the top and basically says, okay, and even if they did it for a short period of time, they might be able to start getting rid of a bunch of stuff. But also considering what they're doing in BC is also very important because the pre-charge screening is like something that my colleagues in BC who practiced in Ontario and now practice in BC really recognize the difference. And pre-charge screening is awesome because you have an opportunity to, in some cases, even talk to the Crown before your client even gets charged and convince them not to charge. Right.
yeah,
So, like for instance, your client got arrested, he gets arrested, they send them like an HTA matter. Sometimes they don't charge, they have 6 months to charge an HTA.
yeah,
Client retains a lawyer compiles or whatever. For instance, the way you do it, a memo, you might talk to the Crown attorney and say, before you guys decide to charge, I mean, I have X, Y, and Z already lined up. I have this, I have that. And you can persuade the Crown not to lay the charge.
yeah,
Right.
yeah,
And then the justice system is not being bogged down by
yeah.
those cases. It really is like something that should be considered, especially early on. And it would help a lot, I think, in getting rid of a lot of the new charge and the
Uh,
new
And we have
charges.
something, I mean, it's not exactly the same thing, but a little bit similar in the youth world where we have the extrajudicial, like we try to do everything before we get a youth case into criminal court. So if there are ways to deal with it outside of courts, we'll do that. But maybe it's not a bad idea to have something like that even in the adult world where if a case is not that serious or it can be dealt with differently, and there are other concerns in the case that can be addressed adequately without bringing it into criminal courts, I think that's a really important way, and it can reduce a lot of the stress that we're all feeling. I think we can all agree, whether it's defense lawyers, crowns, or judges, we're all feeling a burnout right now. There are way too many cases, and I mean, something has to be done. But maybe this system that you were talking about, Marco, should be brought back. I mean, I hope.
I'm not going to be one of these old men say, back in my day, we used to do this. I don't know if it's better. I don't know if it'll help. From a very high level, it seemed that it was something that was working. And I recall there being a lot of resistance from many crowns on a off the record discussions would tell me that they're not looking forward to vertical case management. But I guess their voices were not heard. The decision was made, and that's where we are
Well, you never know. Maybe someone, important is watching this, will be watching this episode, and maybe they will reconsider, right? Because it will really help everybody in the system. It's not just a defense problem, it's everybody's problem. And most importantly, it's our clients' problems because really, at the end of the day, it's the person who's facing the criminal charge who's living the most stress and anxiety. Like we're all stressed out, but it's nothing compared to what our clients are feeling when they're facing the charges and their lives are on hold. So I
That's right.
hope I hope this discussion, I know online there are a lot of discussions between lawyers about these issues, but it's nice to have one on video, and I hope it will help and that someone will do something about it. But thank you,
Thank you.
Marco, for coming back, Wicked Ally, and we hope to see you soon again. I mean, you're an ally, so we know you're going to be back. But it's always nice to see you, and
Anytime.
thank you for sharing your thoughts with us
Thanks
today.
for having me, Maya, and thanks for all the work you're doing, and congratulations on the new position.
Well, thank you. Thank you very much. It's very nice of you. Bye.
Okay. Bye.